Yes, good evening and welcome to the today class of the the Junior Civil Judge Examinations of the 2022 and Telangana State of Telangana, Karibusana, you are welcome. And just now that somebody has read it, good evening, namaskar, assalamu alaikum, vanakkam, Civil Procedure Code, MCQ, that is the multiple choice questions. Now the first one is Motamari, be ready, are you there? Motamari, are you there? Say yes.
Yes, sir. Can you please give us chance to?
Yes. No, because the people are joining it. No, that's why I am adjusting the time. Yes. Now you can start the JCJ 2022 State of Telangana Civil Procedure Code 1908 multiple choice question and a host because spelling mistake I committed. Host Motamari Sri Vidya. Yes, sir. Take up the first question.
Yes, sir. The first question, Code of Civil Procedure came into force with effect from option 1, 1st January 1908, option B, 1st September 1908, option C, 1st January 1909, option D, 1st September 1909.
Option C, 1st January.
Option C, 1st January 1909.
Yes. Option C is the correct answer. Second question, the code extend to option A, whole of India, option B, whole of India except the state of Jammu and Kashmir, option C, whole of India except the state of Nagaland and tribal areas, option D, both A and C.
Option A, whole of India.
Nagaland and tribal areas.
Yes, option C is the correct answer. A third question, among the following, in which section the term decree is defined? Option A, section 2, subsection 1, option B, section 2, subsection 2, subsection 2, option C, section 2, subsection A, option
Class
D, section
A.
Yes, sir, clause B.
Option B, section 2, subsection 2.
Clause B, clause 2. Okay, ma'am, correct answer. Fourth question, decree includes option A, rejection of a plaint, option B, any adjudication from which an appeal lies as an appeal from an order, option C, where any order of dismissal for default, option D, none of the above.
Option A,
Option
the
B.
rejection of a plaint.
Yes, option A is the correct answer. Fifth question, the Code of Civil Procedure Amendment 1999 as well as the Amendment Act 2000 were held constitutionally valid in the case of option A,
SB, mute.
versus Shivaram, option B, state of UP versus Chandra Bhushan, option C, Anil Roy versus state of Bihar, option D, Salim Advocate Bar Association versus Union of India.
Option D,
Salem Advocates, Bar of Union.
Salem Advocates.
Yes.
With
Famous.
regard to affidavit.
Yes, sir. Correct answer.
Appreciate.
Sixth question, the interest on mean profit shall not include dash per annum. Option A 10%, option B 6%, option C 4%, option D 1%.
6%.
Option B, 6%.
Yes, ma'am.
6.
Option B is the correct answer. Which of the following must be stated in the pleadings? Option A, facta probenda, option B, facta probentia, option C, both A and B, option D, neither A nor B.
Option C,
C, both
A
A and B.
Once again, read the question.
Which of the following must be stated in the pleadings?
Facta probenda is the correct answer. Eighth question, among the following, who cannot be arrested during the execution of money decree? Option A, woman, option B, any person, option C, partner, option D, none of the above.
Option A.
Option A.
Yes, option A, woman is the correct answer. Women are always in an exemption clause. Ninth question, A resides in Dehradun, beats B in Delhi. B may sue A under the code. Option A, Delhi, option B, Dehradun, option C, either A or B, option D, only A, not B.
Dehradun.
Option
C. Sorry. B.
Option C is the correct answer, either A or B. 10th question, a decree for execution cannot be sent to A. Option A, foreign court. Option B, court outside India established by the authority of central government. Option C, both A or B. Option D, neither A nor B.
Option C, both A and B.
Option D, neither A nor B.
Option A is the correct answer, foreign court. 11th question. A judgment delivered by a foreign court for competent jurisdiction can be enforced by an Indian court and will operate as res judicata between the parties thereto, except in a cases mentioned. Option A, Section 14. Option B, Section 13. Option C, Section 12. Option D, Section 11.
Section B, Section 11. Section 11.
Yes, Section 11 is the correct answer. 12th question. The defendant against whom an ex parte decree has been passed can prefer an appeal order under Option A, Order 9, Rule 13. Option B, Order 47, Rule 1. Option C, Section 96, Clause 2. Option D, none of the above.
C.
B.
Option C.
C.
Option
Section
C.
96
Option
clause.
C is the correct answer. Sir, please scroll it down, sir. 13th question. Where the relief claimed by the plaintiff is undervalued and the valuation is not corrected within the time fixed are exempted by the court. Option A, the plaint may be rejected. Option B, the plaint will be rejected. Option C, the plaint will be returned. Option C, either A or C.
B. The plane will be returned.
B.
Option B. Plaint will be rejected.
Option A.
Rejected.
Plaint
Option
may
C
be
is the correct
rejected.
answer. 14th question.
Right
Which
answer,
of the-
give the 13th
Option
question.
A. Option A, plaint may be rejected is the correct answer, sir. 14th question. Which of the following does not deal with the final determination of constructed question and have the binding effect in future litigation? Option A, res sub judice. Option B, res judicata. Option C, stare decisis. Option D, both A and B.
B.
Option C. Option C.
Option B, res judicata.
Yes, option B is the correct answer, res judicata. 15th question. Among the following cases in which the test of res judicata between co-defendants have been laid down by the Supreme Court. Option A, Shobhak Singh versus Jai Singh. Option B, Jay Naren versus Kedarnath. Option C, Mahbub Shah versus Syed Ismail. Option D, Shayadan Singh versus Darya Kanwar.
Option D.
Option C. Mehboob Shah.
Yes, option C is the correct answer, famous case law. 16th question. Which of the following operates as res judicata? Option A, a withdrawal of suit. Option B, an ex parte decree. Option C, a compromise decree. Option D, none of the above.
None of the
Option
above.
B.
None of the above.
Option D. None of the above.
Is correct answer. 17th question. The provisions relating to abatement does not apply to. Option A, appeals. Option B, execution proceedings. Option C, both A and B. Option D, none of the above.
Option D, appeals.
Appeals.
Appeals is a correct answer. 18th question. After rejection of plaint, whether the plaintiff can institute fresh suit on the same cause of action. Option A, can institute another suit. Option B, can institute another suit with the permission of High Court. Option C, cannot institute another suit. Option D, both A and B above.
Option A, can institute
Option
another.
A. Can institute.
Option A is the correct answer, can institute another suit. 19th question. After the first hearing of suit, the court may, option A, frame and record the issues. Option B, ascertain upon what material prepositions of fact or of law the parties are at variance. Option C, record the evidence. Option D, none of the above.
Option A, frame and record the issues.
D, madam.
Option B is the correct answer, sir. Ascertain upon the material prepositions of fact or of law, the parties are at variance. 28th question. Under Order 7, Rule 11 of Code, the plaint shall not be rejected. Option A, where it is not filed in duplicate. Option B, where the suit appears from the statement in the plaint to be barred by any law. Option C, where the plaintiff fails to compile with the provisions of the Rule 9. Option C, where it discloses cause of action.
Option A, where it is
Option
not
D.
filed.
Where is the disclose the cause of action.
Pardon? Sir, again.
Option C.
Option D.
Yes, option D is the correct answer. 21st question. Application under Order 9, Rule 7 of the to set aside the order of ex parte, proceedings may be filed. Option A, at or before the date of fixed for hearing. Option B, within 90 days. Option C, within 45 days. Option D, within 30 days.
Option D.
Option D within 30 days.
Option A, at or before the date of fixed for hearing. Option A is the correct answer. 22nd question. The doctrine which place emphasize on the plaintiff's duty to exhaust all available grounds in support of his claim. Option A, estoppels. Option B, res judicata. Option C, principle underlying Order 2, Rule 2. Option D, none of the above.
Option C.
Option C is the correct answer. 23rd question. Remedy available against rejection of pleas. Option A, plaintiff may prefer an appeal. Option B, plaintiff may present a fresh plaint in respect of the same cause of action. Option C, either A or B. Option D, none of the above.
Option C.
Option C. Either A or B.
Yes, option C is the correct answer, ma'am. 24th question. Sir, please scroll.
Yeah, it is visible.
Options are not visible, sir. Yes. A claim by way of dash may be allowed even if it is time barred when there is fiduciary relationship between the parties. Option A, an equitable set off. Option B, a legal set off. Option A, counterclaim. Option D, all of the above.
C. Counterclaim.
Counterclaim.
Option A is the correct answer, an equitable set off. 25th question. A suit filed on behalf of a minor. Option A cannot be withdrawn. Option B can be withdrawn as a matter of right. Option C can be withdrawn only with the leave of the court. Option D, none of the above.
Option C.
Option C.
Yes, can be withdrawn with the leave of the court. Leave of the court means
Yes, thank you very much, Sri Vidya Mutamari. That now the turn is the host, Kolikon Sharad Babu. Are you ready?
Yes, sir.
Go through. First
Good
question.
morning. Good morning to our mentor, Professor Hussain sir, and all the participants, and my co-host, Sri Vidya.
Proceed. Any problem?
Option C, 23 capital A. Option D, 21.
Option B.
Option B.
Yes, option B is the correct answer. 21 capital A. Now, the second question is the repealed section 48 in CPC 1908 pertains to A. Option A, transfer of legal representatives. B, procedure in execution. C, limit of time for execution. D, attachment of property.
Option A.
Procedure in execution.
This is related to Limitation Act.
Yeah.
Option C.
Yes,
C.
option C is the correct answer. Limit of time for execution. So that is repealed section 48 in CPC 1908. Third question. At any time after a warrant for the arrest of a judgment debtor has been issued, the court may cancel it on ground of his serious illness. The provision is according to section A 159 of CPC, B 50 of CPC, C 51 of CPC, D 59 and 60 of CPC.
51 of 60. 59 and 60.
9 and 60 of CPC.
Option 59.
59.
59.
Option D is the correct answer. It is 59 and 60 of
60. Yeah.
Section-
59 grounds of
section
serious
59
illness.
and 60. Yes. Fourth question is that CPC 1908 came into effect from, of course, it is already answered one. Option A, 1st March 1908. Option B, 2nd January 1908. C, January 1908. D, 1st January 1908. D, 2nd January 1908.
Option C, first.
Yes, option C, 1st January 1908. With that date, it came in effect. Fifth question. Section 2, Clause 3 of CPC 1908. The Act extends to the whole of India. Slightly modified one. This is to the Srividya's question. A, except the state of Jammu and Kashmir and Assam. B, except the state of Jammu and Kashmir. C, except the state of Jammu and Kashmir and the state of Nagaland and the tribal areas. D, none of the above.
Option C is none of the above.
None of the above.
Option C is the correct answer. We are talking about CPC 1908. Except the state of Jammu and Kashmir and the state of Nagaland and the tribal areas.
Sir, now it's included, sir. Jammu and Kashmir is included, only except Nagaland and tribal.
But we are talking about 1908, when it was first formulated. We are not talking about the amended act.
Anyway, subject to correction.
It's need to correction, right, sir?
Yes,
We
but
have only
we have to
1908
quote the
CPC,
amended
sir.
act.
We have to read 1908.
Okay.
According to 1908 Act, we are talking. Sixth question. The High Court of Andaman and Nicobar Islands means A, the High Court in Chennai, B, the High Court in Kolkata, C, the High Court in Delhi, D, the High Court in Mumbai.
So the best of my knowledge, it is Kerala.
Chennai,
B, sir. Kolkata.
Kolkata, sir. Kolkata.
Yes,
Option B, High Court in
answer,
Kolkata.
the High Court in Kolkata. Seventh question. Mesne profits of property do not include option A, those profits which the person in wrongful possession of such property actually received. B, those profits received with ordinary diligence from profits arising from wrongful possession of that property. C, profits received together with interest on such profits arising from wrongful possession of property. D, profits due to improvements made by the person in wrongful possession of the property.
Option D.
Option D.
Yes, option D is the correct answer. Profits due to improvements made by the person in wrongful possession of property will not come under mesne profits. Eighth question. Pecuniary means A, to persons, B, relating to office, C, relating to money, D, relating to, that has missed.
C. Answer C.
Option
C.
C.
C, sir.
Yes,
Relating-
option C is the correct answer. Relating to money. That is the pecuniary. Ninth question is suits by indigent persons is dealt by A, order 32, B, order 33, C, order 30, D, order 31.
Order 33. 33.
Order 33, sir.
Yes, option B is the correct answer, order 33. 10th question. In accordance with order 32, suits shall be instituted by or against A, minors, B, persons of unsound mind, C, trustees, D, minors and persons of unsound mind.
C.
Option D is the correct answer, minors and persons of unsound mind. 32, order 32. 11th question. Where a decree is sent for execution in another state, it shall be sent to such a court and executed in such manner as may be prescribed by rules in force in that state. It is stated in section dash of CPC. A 40, B 42, C 45, D 41.
D.
Option
40.
A.
40. 40.
Option A.
This option A is the correct answer, section 40. 12th question.
Yes, yes.
Bleeding shall mean plain or written statement is stated, pleading is to plaintiff and statement is used in order 7 of CPC, order 6 of CPC, order 8 of CPC, order 9, order 11 of CPC.
Order 6.
Option B, order 6 of CPC.
Yes, order 6 of CPC, option B is the correct answer. 13th question. Plaintiff is to plaintiff while, this should be just modified. Plaintiff is to plaintiff while written statement is to A,
Defendant.
decree holder, B,
Defendant.
judgment, debtor, C, appellant, D,
Defendant.
Yes, D is the correct answer, defendant. 14th question. A summons may be issued in the defendant where a suit has been, just scroll it,
Down, yeah.
where a suit has been duly instituted to appear and answer the claim and may be served in manner prescribed on such day and beyond 30 days from the date of institution of the suit, as per this should be corrected, sir, as per rule dash and order dash of CPC. Can anyone answer?
Yeah,
The
30 days.
answers are not
Yeah.
here.
90 days.
Rule
90 days.
and order. Which rule and which order of CPC?
Order 5.
Order
Five.
8, rule 1.
Rule 1, order 5. Rule 1 and order 5. Next question, 15th question. Clerical or arithmetical mistakes in judgments, decrees or orders or errors arising therein from any accidental slip or omission may at any time be corrected by the court, either all of its own motion or on the application of any of the parties as per section A 160 of CPC, B 151 of CPC, C 152 of CPC, D 154 of CPC.
152.
Option C is the correct answer. 152 of CPC.
Yes, option C is the correct answer. 152 of CPC. 16th question. After application of parties and admission of affidavits, the Supreme Court may transfer a suit to another court if it feels the application is vexatious or frivolous. Then the court may order the applicant to pay compensation to any person who has opposed the application, which shall not exceed A, INR 3,000, B, INR 1,000, C, INR 4,000, D, INR 2,000, Indian National Rupee.
Option A is the correct answer. INR 3,000 rupees.
3,000, sir.
Option D, sir.
Option D is the correct answer.
Option A,
INR
3,000.
2,000. According to section that is 25 CPC. 17th question. An objection can be raised as stated in section 21 of CPC against the suit with regard to A, the place of suing, B, pecuniary jurisdiction of the court, C, territorial jurisdiction of the court, and D, any of the above.
Any of the above.
Yes, option D is the correct answer. Any of the place we may sue according to section 21, the place of suing or pecuniary jurisdiction or territorial jurisdiction, any against anything we can raise objection. 18th question. The principles governing execution of decree and orders are dealt with in section A, section 35 to 74 and order 21 of the Central Civil Procedure Code. D, section 36 to 74 and order 21 of CPC. C, section 37 to 74 and order 21 of the CPC. D, section 34 to 74 and order 21 of CPC.
D, sir. D.
Option B is the
Section
correct
36 to
answer.
74.
Section 36 to 74.
And B is the correct answer. Sections 36 to 74 and order 21 of the Civil Procedure Code. 19th question. According to Rule 39, Order 21 of the Code of Civil Procedure 1908, subsistence allowance to the maintenance of judgment debtor who is to be arrested shall be paid by monthly payments in advance before the first day of each month by A, judgment debtor himself, B, the executing court, C, the government, D, the decree holder.
D. Option D.
Option D is the
Option
decree
D is
holder.
the correct answer. The decree holder has to pay the subsistence allowance for the maintenance of arrest in case a judgment debtor is arrested. 20th question. In any case, the court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for the payment of money according to A, Section 53, B, Section 56, C, Section 51, D, Section 5.
Option B, section 56.
Yes, option B, Section 56. Now, 19th question. Dash, a public officer is exempted from arrest and personal appearance in certain acts and situations in official's capacity as laid down in section A 82, B 35, C 80, D 81.
Option A.
A 82.
81.
Option C, sir.
80. C.
I also have some doubt.
Public officer.
It is on 82.
Yes, section 82, according to section 82. A public officer is exempted from arrest. Now, 20th question. Every person residing in a foreign country, the government of which is at war with India and carrying business in that country without a license in that behalf granted by the central government shall, for the purpose of this section, deemed to be A, an alien, B, an alien friend, C, an alien enemy, D, a fugitive.
Option C.
Option C is the correct answer, an alien enemy. Question number 21. The prescription of procedures and method that govern civil procedure in India is regulated by dash of CPC 1908. A, sections, B, orders and rules, C, orders, D, rules.
Option B.
Option?
Option B. Orders and rules.
Yes, option B is the correct answer, both orders and rules. 22nd question. A defendant to whom a summons has been issued under sub-rule 1 of Rule 1 of Order 5 may appear A, in person, B, a pleader duly instructed and able to answer all material questions relating to the suit, or, please scroll down, sir. C, both the defendant and plaintiff, B, C, by a pleader accompanied by some person able to answer all such questions, D, any one of the above.
Option A, in person. In person.
Option D, any one of the above. Either person or a pleader duly instructed or a pleader accompanied by some person. Anyone can. 23rd question.
What is the answer for what is the answer for the 22nd question?
Option
D,
D.
any one of the above.
Okay.
C, sir.
No, sir. Anyone may appear. Anyone may appear.
Next.
23rd question. When the court sees reason, it may order the personal appearance of the defendant only, B, the plaintiff only, C, both the defendant and plaintiff, D, none of the above.
Both. Option C.
Option C, sir. Both the defendants and plaintiff.
Yes, option C is the correct answer, both the defendant and plaintiff. 24th question. Order 14 of CPC deals with A, disposal of suit at the first hearing, B, power of imposing cause, C, evidence, D, framing of issues.
Option D.
Framing of issues.
Option D is the correct answer, framing of issues. 25th question. According to Order 19, every affidavit must comply with the form with all the relevant duties and events in A. Logical order, B. Chronological order, C. Rational order, D. Recorded order.
Option B.
Chronological order.
Option B is the correct answer, chronological order. 26th question. In which case the apex court had remarked that even though there is no time limitation provided under Civil Procedure Code, an unreasonable delay in pronouncing the judgment after hearing is done unless substantiated by unavoidable circumstances is highly unacceptable. A. J. Rubber Co. India Private Limited versus Mehta Suraya and IPM versus United Investment Corporation. B. State of Punjab versus Shamlal Murari. C. R.C. Sharma versus Union of India. D. Sinha Ramanuja versus Ganga Ramanuja.
Option D.
Option C is the correct answer. R.C. Sharma versus Union of India. In this case, undue delay is not acceptable. That verdict was given by Apex Court, that is Supreme Court. Now, 27th question. Section 11 of CPC 1908 decides a matter that has been adjudicated by competent court shall not be pursued further by the same parties in any court. It is called already or A. Ratification, B. Res judicata, C. Stare decisis, D. Res sub judice.
Option B.
Option?
Option B. Res judicata.
Yes, option B. Res judicata. 28th question. One of the following is a famous case law for review of res judicata. A. Kamla Jora versus State of Uttarakhand and another. B. Satyavati versus Rajendra Singh and another. C. Satsang Kendra yet Baramunda versus State of Orissa and others. D. Thomas Press India Limited versus Nanak Builders and Investors Private Limited and others.
Option D, sir. Thomas Press.
Option A, Kamal Zora versus State of Uttarakhand. This is for review of res judicata. And some of the cases I am giving here in the feedback, these are some famous case laws for review as per based on CPC. A, Kamal Zora versus State of Uttarakhand and another, that is according to section 11, that is res judicata. Second, Satyavati versus Rajendra Singh and another, that is based on section 47 review. 3. Satsang Kendra at Baramunda versus State of Orissa and others, that is based on Order 1 and Rule 10. 4. Thomas Press India Limited versus Nanak Builders and Investors Private Limited and others, that is based on Order 39 and Rule 1. 5. Shiva Prasad Das versus Vaishachali Jatiya Samiti Katak, that is also based on Order 39 and Rule 1. These are reviews of those sections based on CPC.
Yes, thank you very much, Kolikonda Sharad Babu, for your hosting the CPC today. And it is my turn, and I believe that 10 minutes we do have in our bank, in our purse. Yes, the first question goes in this manner. Find out which one is wrong statement. A. The Code of Civil Procedure 1908 governs the practices and procedures to be followed in the civil courts. B. The primary goal of this civil procedure code is to consolidate and amend the law governing the procedures and practices used in the Indian Civil Code. C option, the Civil Procedure Code governs all actions in civil courts and the parties involved until the order and decree are carried out. And D, none of the above. A wrong statement, I say, among the four.
Option D, none of the above.
Wrong.
A.
Option D.
Option C.
Tell me why option C is the wrong for the right question of the first question. Reason. The Civil Procedure Code governs all actions in civil courts and the parties involved until the order, whether the order will be given by the civil court first or the decree will be given the civil court first. Say, which will be given first in civil court? Order or decree?
Order.
Order.
The Civil Procedure Code governs all actions in civil courts and the parties involved until the decree and order are carried out. Then
Yes, order is final, but decrees, preliminary decree like that will be issued.
But there is a difference between order, decree, and a judgment.
I think the decree would be then the order will be passed.
No. Orders are
Order will be
instructions.
passed or the decree will be given.
No. Orders are instructions. It is like, I can give one example, the difference between an order, decree, and a judgment.
Okay, please.
Order is like when the teacher tells the student how to write the exam, like you should not copy, those are the orders.
Okay.
And judgment is like a student writing a questions, answers. That is called judgment. And decree is whether you have passed or not, that is a decree.
Then can you tell me that what is the first question right answer is?
It's order, judgment, decree. The procedure is that.
Okay. Anyway, that I do admit it, but I found it the decree comes first, the order comes later.
No, order comes
Subject to
first.
the correction.
Order the instructions.
Okay, agreed. Subject to the correction. Second question. Which is odd man out? A option. The code is made up of 158 sections that make up the substantive part of the code. B. 51 orders and make up the procedural part of the code. C. The Civil Procedure Code was enacted 1908 and went into effect on the January 2, 1909 and all of the above.
Option C. It's first Jan, not second Jan. Option C.
Option
C, sir.
C.
Sir.
It is the 1st January 1909, but the rest of the things are very much relevant to it. Okay, the third question. Which is correct as per the Civil Procedure Code? A code as defined in section 2, subsection 2 of the Code of the Civil Procedure 1908 is a set of rules that governs the movement of case in court. B option, the Code of Civil Procedure 1908, which is a procedural law by nature, governs the criminal proceedings in Indian territory and is thus recognized as a code. And C, the section and the Code of the Civil Procedure addresses the general principles of jurisdiction, whereas the orders and rules outline the procedure and methods of the governing civil proceedings in India, all of the above.
Option C.
Option B.
Why option C is the answer? Wrong.
Option B, sir.
Why B is the right answer for the question, third question? Give me the reason. Don't shoot just merely. The question is, B is the right answer for the question because this is the correct as per the Civil Procedure Code. Is it the correct or is it a wrong? Code of Civil Procedure 1998, which is a procedural law by nature, governs the criminal proceedings or civil proceedings. I think which is the not correct is the way of asking. Civil Procedure Codes deals the criminal proceedings or civil proceedings.
Civil proceedings.
Now B is the correct answer.
But B is the correct answer because I wrote the criminal proceedings. Is it clear? Say yes.
Yeah.
A code as defined in the section 2(1) of the Code of Civil Procedure. And the Code of Civil Procedure 1990 is procedural law by the nature governs the civil proceedings in Indian territory and thus recognized as a code. So civil proceedings will be dealt under civil code. That's the point. The fourth question.
So
What is correct
careful
statement?
observation of the options is needed.
Yes. Shall I proceed?
Yes, sir.
Okay. Fourth question. One is the correct statement and there are false statements. 3 are false statements. Now let us go to the point. A. There were provincial courts in presidency towns and crowns courts in the Mufsil prior to 1859. Second, B question. Option. The courts in Mufassil's area were governed by the various criminal procedure system based on various rules and regulations that were frequently changed to meet the changing needs and circumstances. C. To provide the uniformity in regulating the civil procedure in India, the Legislative Council of India enacted the first code of civil procedure in 1859, which received the Governor's General's assent on March 22, 1859. The last option D. However, the code was ineffective because it did not apply to the Supreme Court, within parentheses, Crown Courts under the Royal Charter, and the Sardar Diwani Adalat, within parentheses, Principal Courts under the Judicial Plan by the Governor General. 1 is correct statement and 3 are false statement.
C, sir.
Option D,
C,
sir.
sir, to
Why?
provide policy.
Why option C? The right answer is B. However, the code was ineffective because it did not apply to the Supreme Court, Crown's Court, and I will give the why D is the right. First, take the A. There are provincial courts in presidency towns. There is no provincial courts in presidency towns. What courts are there? Crown's Court in the Mufassil. No, it's the Crown's Court in the provincial. And Mufassils, then provincial is the Mufassils. I will show you the answer here. Feedback. In the feedback, read the feedback, anyone?
There were crown courts in presidency towns and provincial courts in Mufsil prior to 1859.
Then I reversed
Courts
it.
in Mufsil areas were
I
governed
reversed
by
it in
various
the first A. So that's wrong. And the second part is, the courts in Mufassil area are governed by the various civil procedures. But what I wrote there? What I wrote there? Various criminal procedures. So that is wrong. Are you following me?
Yes, sir.
See, first one is wrong. Why wrong? In the presidency, there are Crown's courts are there. And in the provincial courts in Mufassils. And the second one is wrong because it deals with the criminal I wrote, but it's the civil procedures. And hence, the third one is, it is the March 23rd. What I wrote? What I wrote?
March 22nd.
March 22nd. So that is also wrong. Then what is left over the right?
Option D.
D.
Option D is the right answer. Now the fifth question. The Code of Civil Procedure of 1859 was also made applicable to the High Courts. However, due to the court's irregularities, it was replaced by the Code of Civil Procedure of which 1875, option A, B option 1876, C option 1877, D option 1878.
And D 1878.
1875.
1876.
1878.
The right question answer is 1877. Next question. The sixth question. Later, the Code of Civil Procedure 1877 was replaced by the Code of Civil Procedure of Dash, which is also failed to overcome the shortcoming of the procedures. Means 1877 is repealed by option A 1880, option B 1881, option C 1882, option D 1883.
Option C 1882.
You are right.
1882.
See, there are many times the civil procedure course is repealed. Then what is the final one?
1908.
1908. That is the Professor Hussain style. Okay, seventh question. Which one is odd man out? Means 3 are relevant, 1 is irrelevant. Option A, section 1 to 8 is a preliminary in nature. Option B, section 9 to 35, capital B, order 1 to 20 of the first schedule deal with the decree. Option C, section 9 states the civil court has a jurisdiction to hear all civil suits unless they are expressly impliedly barred. Option D, section 10 of the Civil Procedure Code 1990 is based on the principle of res sub judice. Which one is odd man out?
Option B. Section 9 to 35.
Option B is odd one.
Wrong.
Section 9.
Section 9, see, because there I made section 9 to 35 B, order 1 to 20. The B1, order 1 to the first schedule deal with the suits, not the decrees. Here. Are you following me?
Yes, sir.
It is deals with the suits, not the decrees. But what I wrote, decree I wrote. But actually it should be
Suits.
suits. That is the odd one out. Is it clear?
Yes, sir.
Yes, sir.
The eighth one, which is false statement or incorrect statement. A reference, it is addressed to the section 113 of the order. How do you pronounce it? XL V1. How do you pronounce it? XLV1. How do you pronounce it in Arabic?
46. Order
46 of the Code of Civil Procedure 1998. Review. It is addressed in the section 114, order 47 of the Code of Civil Procedure 1998. And the revision. It is addressed in section 115 of the Code of Civil Procedure 1998, or all of the above. This is A option, this is B option, and this is C option.
Option D.
I say odd man out, which is not connected. What the question I made? Which is a false statement or incorrect statement. The first one, reference, it is addressed to the section 113 of the order 47, that is XLV1 of the Code of Civil Procedure 1990. Is very much correct. And the review, it is addressed on 114, order 47. Never write Arabic numerals in the order. I repeat, never write order in the Arabic numerals. It should be
Roman letters.
Roman capital. And hence, odd man out is
Option B.
option B. Here I wrote a review. It is addressed in section 114, order 47 of the Code of Civil Procedure 1998. That means XL. X means
10,
10.
L means
4.
50.
oh, I appreciate 50. See, here I have written Roman numericals, how it could be read. L is 50, C is 100, D is 500, M is 1000.
1000.
This is, now one should be very much clear that orders never and ever would be in Arabic numerals. It should be always capital
Numeric form,
Roman numbers. Is it clear? The time is up, but I don't know why the Cisco WebEx is very much kind enough towards you. Okay, this much that I prepared today, questions in the CPC. And if you happen to see the CPC Bear Act, if you happen to see Civil Procedure Bear Act, I will show you something. Civil Procedure Code 1908 Bear Act. Yeah, it is given
So
here.
one thing I want to know whether all these acts in which previously this Jammu and Kashmir was exempted, both civil and criminal, now they are effective in Jammu and Kashmir.
Yeah, because now that they are extended to
Yes,
each and
yes.
everybody, I believe that the Nagaland is not still kept it over there, it seems. But anyway, subject to the
No,
corrections.
I am not asking, sir, whether all the acts
Yeah, all the acts,
are
all the
effective,
acts.
whether all the acts are effective in Jammu and Kashmir, both
Yeah,
civil and
generally when it is
criminal.
scrapped over there, wherever that except comes now, automatically it will be referred. Okay, now next what I want to say is, okay, now we will forget that dispute. Shall I proceed?
Yes,
Okay,
yes.
sir.
How many parts are there in the Civil Procedure Code?
How many parts?
PART, part.
11.
11 parts.
Yes,
There
these
are
are
two
subsidiary
parts, sir. Given
questions.
9
two
parts.
parts only.
Anyway, you
9
check it
parts.
because I'm giving the subsidiary question. See, part 1, part 2, it is clearly written over there.
Part 11 is miscellaneous. Part 10 is
11.
rules.
Anyway, that
Nine.
I am giving you the technique. I am giving you the mode. I am giving you the way. I am giving you the way it can be asked. Is it clear?
Yeah.
Then they may ask, which is the saving clause in the CPC? They may be asked because generally the saving clause last, but one will come under the saving clause. And when a capital A is added to the section, that means it will be added in the amendment, other amendment to the main section.
Saving clause is always in the miscellaneous clause, miscellaneous chapter.
Yeah, that's miscellaneous comes always the last.
51.
Miscellaneous clause comes always in the
Last.
last.
Sir.
So here they part 9 also there, and here part 10 also there, part 11 also there, miscellaneous, and right to large account, and let us see that repealed clauses are there. Then the references generally saving and inherent, see, saving of inherent powers of the court. So it comes in the mostly the last part of it. And how many schedules are there? How many appendices are there? Suppose if I give the appendix A, B, C, D, then I will give the other jumbled order and say match the following from the appendix A to the explanation given in the part B. So appendix A deals with the pleadings, appendix B deals with the process, appendix C discovery and inspection and the admission. So probability is there, they may ask also at one side appendix, in the other side its explanation. Is it clear?
Yes.
Yes, sir.
Yes. Then they will say the second schedule, third schedule, fourth schedule, fifth schedule.
All repealed.
Can you tell me
Yes.
what is the difference between repealed and deleted? Anyone? See, generally the word we can say repeal even for the statute or even for the section. But if there is amendment would be there, something will be added over there. At the time, that was deleted and this is omitted, not generally say omitted, and they inserted. So sometimes I don't think the delete word can be used there in the legal terminology. Because omission is there, omitted, repealed is there.
Repealed is outright removal.
Yeah. Then what about delete? There is some distinction I found it because when I was reading in a general
In
class.
case of words, sir, in case of words, they may be deleted and sometimes may be substituted by some words or may be completely deleted.
See, now let us see the right to lodge a caveat. You see that section 148 capital A, it is added in the amendment to the main clause. When you are added, no, never ever write any punctuation between the Arabic numerals and the capital. I repeat, never ever write any, I will show you here, punctuations when you added it. Never write, because sometimes they will ask you that. So let us presume it 148A. This is the style of writing. Is it clear? But never write hyphen. Or you cannot write again one. Yes, mute. Sumalata, mute. You never write in this manner also. The way it is given in the statute, the same style you have to adapt it. Because they may confuse it also. Sometimes they will write here. In the last class I told you, 5. A 5 can be written with the words, figures. Only the words could be written over there. Not Roman 5, not small Roman 5, not Arabic numeral 5. It should be the words FIV 5 is written yesterday class that I dealt. So whenever a new section is directly added to the section, main section, you should not go with any punctuation. It should be 148 capital A without any punctuation between the Arabic numeral and the alphabet capital A. So that is the style that you have to adapt it, because they may ask such a thing like that. 148A, right to lodge a caveat. What is meant by caveat? Anyone?
Informing the other party before filing a case against that person.
No, sir.
And the duration is 90 days.
Stay
Caution notice to the court.
stay cannot be granted in that case.
Without informing him.
Against the
Always inform the other party with the notice.
Yes.
What is caveat emptor?
A person who files the caveat.
In law of contract, there is a caveat emptor. Let the buyer
beware.
Beware.
Beware the buyer.
Beware of
yes, and Kolikonda Sharad Babu has made mesnef profits. What is meant by mesnef profits?
Profits made from an illegal custody.
Any profit
from illegal
gained
property.
illegally,
Illegal position.
Wrongful possession.
and that should be proportionately given to the owner of the property
Yes.
after deducting the expenditure.
The improvements that he has made, for that he can retain, but other profits should be returned.
Yes. So that was the thing, the CPC will come. But anyway, I am very much thankful to the Cisco WebEx. They are kind enough.
Between omitted and repealed is
Yes. So with this, I would like to wind up. And what would be the next class? Have you seen the schedule?
Contract, sir. Contract,
After
sir.
CPC, what comes next?
Contract, sir.
Contract. Yes. Be ready with the contract and come to the class and participate it. But one thing is very much clear. After reading the fourth option by the host, then only you shoot it. But I know that you are irresistible to say once it is completed. Yes, that would be a quite good idea. But after the completion of the fourth option, you can shoot it. That would be my request, number one. Number two, when you don't speak, please mute it. Suppose you are alone in the room, you need not to mute it because other sounds will not come. But you are in the room and where the other people also speaking, I could hear, not only I could hear, everyone could hear what the dialogue would be there. And hence, if you use the headphones, of course, no disturbance will be recorded over there. And that one should have to follow it. And please don't post anything in the Junior Civil Judge 2022 Telangana State WhatsApp group. It is only to alert you what we are going to deal and how many are attended over there. If you want to ask anything, please, you know my number. You can ask me directly. WhatsApp number. What's my WhatsApp number? I already shown you. I already shown you. I don't know whether.
Your number is already in the WhatsApp. No, why? Your number is
In
visible
exam
in the
also,
WhatsApp.
sir, it is always the best way to answer after reading the questions and options completely.
Yes, that's the, because the person who is absent, he could hear it by watching it, all the answers, and he can give the answer which would be the appropriate. So that is the way that we can make it out.
It is the judge's way. It is the judge's way.
Yeah, yes. That is the way that one should have to make it out for the answers. So with this, I would like to wind up. See here, you can ask me because I am the coordinator for this team, and because you number, I put it over there, my number, that is the +91 is the code of India, 970-1440-939 is my WhatsApp number. You can ask me, but don't post in the group. With this, I would like to wind up my today's class and be ready for the tomorrow class. That is the law of contract. Up to that extent, I say Asante Sana. Thank you very much. And let you meet tomorrow. End of the meeting. Jai Hind.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आभार प्रचारित सुनि तव उदार वाणी